Mr. Fry in here somewhere? No. Miss Adams?
Yes, Judge.
Can you contact Brian Fry and Attorney Carson and let them know you're going to need to get another date?
Okay.
All right, thank you. Is Andrew Milner a name on this file? No. All right, Miss Olson, can you hear me?
Yes, Your Honor, thank you.
Mr. Kraft, can you hear me? Okay, so Mr. Kraft, we do not have audio on you. So we cannot hear you, so it may be you need to scoot up. No, we do not have audio. Are you both appearing today?
Yes, Your Honor.
So let me get audio on him. And Mr. Stevenson. There's no guidelines in this at all, correct? Mr. Fry, if you can unmute your device and start your video.
Yes, Your Honor.
Mr. Fry and Mr. Carson, I've had some lengthy sentencings this morning, actually like 3 or more. So I am not going to be able to conduct your hearing. So if you could reach out, perhaps in a chain email with Miss Adams to get another date.
Thank you, Your Honor. Will do.
All right. Thank you. I'm going to dismiss your clients too.
Thank you.
Mr. Kraft, have they? Okay, so I know I can't hear you, Mr. Kraft. Sometimes they need to call back in or connect the audio. So we'll give you a moment for that. Mr. Milner?
Yes.
And Ms. Rucella Charters. I've had some hearings that have gone over this morning, so I've advised your attorneys to contact my office to set up a date for another hearing, so we won't be proceeding today, all right?
Can you hear us now?
Yes, I can hear you, Mr. Kraft. So Ms. Charters and Mr. Milner, you're all set.
Okay, thank you.
Thank you.
I hear you, Mr. Kraft, you're good. Can you hear me?
Yes, ma'am.
Okay. All right, so this is in the matter of the people of the state of Michigan versus Paul Coy Kraft, file number 1975-009988FY. I have Tina N. Nolson, P82299, appearing from the State Appellate Defender's Office on behalf of Mr. Kraft. And I have Jennifer L. Bruggeman and Jacqueline Weiss appearing on behalf of the people. So this is a date and time scheduled for a resentencing. But first, Ms. Bruggeman, there is a motion to adjourn the sentencing. Would you like to address that first?
Yes, thank you, Your Honor. Your Honor, I filed the motion to hold Mr. Kraft's resentencing in abeyance. I'm sure the court has read my motion and Ms. Olson's response. I would just again reiterate a few things. Obviously, we're here in front of the court today because of People v. Parks as well as People v. Pool. This court had held Mr. Kraft's motion for relief from judgment in abeyance pending the outcome in Poole. Poole, I am not ignoring the precedential value of Poole. However, I think it is very noteworthy that Wayne County did decide to appeal that decision. And even though it's a published decision in the Court of Appeals, it was a very narrow decision. It was a 2-to-1 decision in that court. And they did decide to appeal that to Michigan Supreme Court. They have filed their application. Sato has filed their response. That was in April. In looking at the Michigan Supreme Court's website, they do typically make a decision on applications within typically 4 to 6 months as far as whether they're going to grant or deny. We are asking that this court at least hold this in abeyance until such time that the Michigan Supreme Court decides the application, whether they're going to proceed forward with it or not. If they deny it, then obviously we can set this resentencing ASAP because it's done. I think the magnitude of this decision, and while I understand and appreciate that it quote unquote only affects 276 prisoners, it still is a very significant decision, allowing resentencings for LWOP defendants who are 18. Mr. Kraft has been in prison for almost 49 years. We acknowledge that, but he was given a life sentence. And the victims in this case have been impacted over the course of their lives because of Mr. Kraft's actions. We don't think that what we're asking is ignoring Poole or that this court doesn't have the authority to do that. I do believe you do. You have granted Mr. Kraft's motion based on Poole, and I think that that's appropriate. But when to resentence him is in your discretion, Your Honor. And I would ask that that be delayed, again, because of the application that's pending. I guess other than that, I would just rely on my motion and I'm happy to answer any other questions. The only other thing I guess I would say is Wayne County, or in her response to my motion, Ms. Olson did indicate that there have been other resentencings that have gone forward, even in Wayne County, but also Wayne County has filed these kinds of motions seeking abeyance in some of their cases. So there's been very few resentencings as with regard to Poole. And so if this court proceeds with resentencing and Mr. Kraft is released on parole, which I know this court has no say in, but the likelihood of that, given the statute, the likelihood if Poole is overturned, the likelihood of MDOC, of him going back to prison is probably very slim. And while again, I don't know that either, just given the practicality of it, it just does not seem likely. So I would ask this court to consider that in making their decision, and I'll leave it at that.
All right. Ms. Olson?
Yes, Your Honor. As the prosecution acknowledges, this is a published precedential decision. The prosecution was aware of the Poole leave application at the time they agreed to this resentencing date. That's very clear from the filed response to Mr. Kraft's bond motion, which references that filing. So there's no authority to not proceed under a published binding precedential opinion whatsoever. In fact, I took a dive into the history of the rule, and the rule was actually changed in 1987 to avoid this very scenario. And the history of the rule is laid out in the case of Johnson v. White, 261 Mishap, 332 at 348 and 349. And that's because, people wanted to say, let's not go forward as we're supposed to do under a published precedential binding opinion. And the rule was amended so that that was not the result. Had Wayne County wanted these resentencings to not go forward, they could have filed a motion to stay the effect of the proceedings in the Court of Appeals. That happens all the time. They chose not to do that. Likewise, the Michigan Supreme Court, if it was so inclined, could order that such proceedings be stayed as they consider this matter. And they have chosen not to do that. So there's no authority for the court not to proceed under the published binding precedential opinion. I'm not aware of any case in Wayne County where Wayne County has sought to obey a pool resentencing. To the contrary, I have talked frequently with the attorney, and my other attorneys talked frequently with the attorney handling these matters, and they're going forward. We have resentencings in Wayne County scheduled in addition to those I've referenced in my filings. So these resentencings are going on. They're going on in other counties throughout the state, as I also referenced in my response. I'm aware of a resentencing that occurred as recently as last Monday. So these resentencings are occurring. There's no authority for them not to go forward. Mr. Kraft's been in prison for 49 years and 11 months. I'm very aware of the fact that we are 1 month away from the 50th anniversary of Officer Williams' death of this offense that occurred. I'm very aware of that. And that the prosecution's asking to obey this resentencing is not going to do anything but prolong the proceedings, cause there to be additional proceedings, and really do nothing to alleviate any harm to the victim family or the community. There's really nothing there, and there's nothing there to support not going forward. So I request that we do go forward today as was scheduled, Your Honor, and as is mandated by the granted motion for post-judgment relief and by the pool case itself. The victims have been notified. They have given their impact statements. The updated pre-sentence investigation is ready. There is no legal basis for prolonging this, Your Honor. It will only cause future issues. So we need to go forward today, Your Honor.
Anything else, Ms. Brugman?
No, Your Honor.
So in this case, the Court of Appeals issued that as a published opinion. Therefore, it is binding precedent, and the court must follow the rules as set forth in this case. Both parties have provided documentation. There's no indication that any other courts are not continuing to hold resentencings. Therefore, under the case law, I feel that it's necessary that we proceed. I don't believe I have the discretion not to proceed today. All right. So, Mr. Kraft, there has been an update to the pre-sentence report. Did you have an opportunity to review that with your attorney?
Yes, ma'am.
And you
Yes.
received that as well, Ms. Brugman?
Yes, Your Honor.
All right. And did you have an opportunity to discuss that with your attorney?
Yes, Your Honor.
Are you satisfied with Ms. Olson as your attorney and the advice that she's given you?
Yes, Your Honor.
So, Ms. Brugman, obviously, none of us here today were practicing law at the time the original pre-sentence report was done. But and there is an update that Mr. Stevenson provided. Do you wish to explain or challenge the accuracy or relevancy of any information in either of those reports?
No, Your Honor. The only thing no, Your Honor.
Okay. And Ms. Olson, do you wish to explain or challenge the accuracy or relevancy of any information in either the original or the updated pre-sentence report?
Your Honor, I have just 3 corrections to the updated report.
You may proceed.
The first is on page 1, the second paragraph. Mr. Kraft did not plead guilty to first-degree murder. He pled guilty to open murder, and that should be changed to reflect that.
All right. Would you agree with that, Ms. Brugman?
I would agree that he pled to open murder and that he was found guilty by the court of first degree. So in fact, then it was a judge decision on the degree. So I have no problem that he pled guilty to open murder, but he was found guilty of first degree murder.
Any objection to that language being added, Ms. Olson, by the Michigan Department of Corrections?
No, Your Honor, I think that's accurate.
Okay. Very good. And the second,
My second correction is in the last paragraph on page 1. It states that Mr. Kraft has a total of 46 misconducts, and the first was on July 23rd of 1987. This is a very old case, Your Honor. MDOC record keeping did not reflect everything it should have in its summary because it's such an old case. So he entered prison in 1975, and in the interest of full disclosure, he had some misconducts in his early years. I was not able to ascertain precisely how many, and the nature of them as described in the pre-sentence report is correct. I would suggest striking the first 2 paragraphs of that and stating Mr. Kraft had 46 misconducts between 7/23/87 and 6/21/22. I tried to think of a way to phrase, as well as some additional ones in his earlier years of incarceration.
okay, that are not documented. So, Mr. Stevenson, can we add that language?
Yes, I'll make that change.
Okay, so we will make that change to add those.
And the third objection I have is the last sentence on paragraph 2, which is the recommendation. I request that that be stricken. That's not a legal sentence.
Hold on a second. So you're not talking about, are you on the update page?
What it was my page 2, Your Honor, the recommendation at the end.
Okay. It is recommended that no changes be made to his sentence, that he continues to serve the sentence of natural life. That one?
Yes, I request that be stricken, Your Honor. That's not a legal sentence as this case is currently postured.
Ms. Bregman?
I have no objection to that being stricken. If we want a clarification on why he is back, we could just simply reference people be pool and the statute that the court is bound by, MCL 769.25.
So for Mr. Stevenson's benefit, you're asking that that be stricken and state what?
Just that Mr. Kraft is to be sentenced under MCL 769.25 as
5A.
as ordered by people be pool.
Okay. Got that, Mr. Stevenson?
Yes.
All right. Any other corrections, Ms. Olson?
That's all, Your Honor.
All right, and there are no guidelines that apply in this.
Correct.
And Ms. Olson, the pre-sentence report, does it disclose any prior convictions in which there exists any known constitutional defect before the original date of sentencing?
I don't believe so, Your Honor, no.
Ms. Bregman?
No, Your Honor.
Okay. So, Ms. Bruggeman, is there anyone that's speaking today?
Yes, Your Honor. Rick Williams, Officer Williams' brother, is here to speak. He also wrote a victim impact statement, which I attached to my memorandum, but he would like to speak. We also have, obviously, a room full of officers. I was contacted by Thomas Ray. He is a retired APD officer, and he also would like to speak. He did provide a written statement, and I did provide that to the court yesterday. I think that's up for debate whether or not he is a victim under the statute, a victim defined as any individual who suffers direct or threatened physical, financial, or emotional harm as a result of a commission of a crime. I will simply leave it up to this court whether you allow him to speak today. I just want to at least make reference to his written statement.
We actually, all right, so I'll let you respond to that, Ms. Olson.
Your Honor, Mr. Kraft and I do not wish to prohibit the officer from speaking if he wishes to do so.
Very good. All right, so
We'll probably start with Mr. Williams.
Mr. Williams, if you could just step up to the podium. Microphones are not the best in this courtroom, so I'm going to need you to speak loudly, okay?
Okay,
Can you state your full name for the record?
Ricky D. Williams.
All right, thank you,
I'm
Mr. Williams.
patrolman Bobby Williams's brother. Today I'm speaking on behalf of my deceased brother, Officer Bobby Williams. Bobby was a Vietnam vet and an Air Force vet. He served in Armed Forces Police in Da Nang in 1969, came home, joined the police department. He was a good citizen. He was a good policeman. He didn't have any ego. He was quietly brave, and he served with his life. On Monday, June 30th, 1975, Bob was an Adrian police officer shot and killed in the line of duty by Paul Kraft. My family has suffered loss and tremendous heartbreak over all these years. My parents have lived under this dark cloud, and so have I. Since then, they were never the same and died with this cloud. I still have it. Paul Kraft had choices and options in life. He could have went to college. He could have joined the Army. He could have gotten an honest job. But instead, he chose to rob a gas station, commit 2 counts of armed robbery, kidnap an employee, and deliberately, cold-bloodedly shoot my brother 3 times, causing him to suffer for hours before he passed away. He was arrested and convicted in Lenawee County and sentenced to life without parole, which was, we felt, an adequate sentence. It would be an insult to my brother's memory and an insult to my parents and family and an insult to the justice system who convicted him. This court convicted. And especially, it's an insult to all of our brave police officers who serve us every day and attempt to keep people like Paul Kraft from injuring the people of our community. I respectfully ask that you give him as much time as possible. Thank you.
Thank you. Next speaker. All right. Good morning.
Good morning, Your Honor.
So step up to the podium and remember you got to speak loud enough. Can you, hold on, can you state your full name for the record?
Thomas E. Ray.
Thank you. All right, go ahead.
We all have certain events in our life that are there forever. I can remember in the 10th grade hearing that John F. Kennedy had been shot. And to this day, I can remember every detail of that. Well, on June 30th, 1975, Paul Kraft, Gerald Deaton, and Leroy Huggins came to Lenawee County from Ohio. Adrian was celebrating 150 years. During the early morning hours, they stopped at the gas station at Russell Road in Occidental. They proceeded to rob the station and took the attendant as a hostage. They ended up in Adrian and were going westbound from Main Street when Bobby Williams effected a traffic stop on the vehicle. Bobby contacted the driver, Kraft, and then walked back to his patrol car. Upon returning to the vehicle, Kraft shot Bobby using a handgun that was passed to him by Gerald Deaton. As they attempted to drive away, Bobby pulled his service revolver and emptied all 6 rounds into the fleeing vehicle. 1 round hit a tire, flattening it. Upon getting to Madison Street, they turned left, believing that would take them out of town. It was a dead end. And they abandoned the car and tried to break into a house. The owner yelled from inside the house that he called the police, and they then fled up and over the bypass. All 3 were apprehended in the wooded area west of the 223 bypass. The hostage was unharmed and had been abandoned by the trio. Kraft and Deaton were convicted of first-degree murder and sentenced to life. Huggins was convicted of the kidnapping of the hostage, but not the homicide. because the jury felt he was in the back seat and not involved. Huggins served his sentence and was released. Deaton ended up dying in prison. Kraft is still incarcerated. This is why we are here today. In 2012, the U.S. Supreme Court, in 2 decisions out of Florida and Alabama, Jackson and Miller, ruled anyone 17 years old or younger could not be sentenced to life without parole. In 2016, the court ruled that Miller should be applied retroactively. In a recent case out of Wayne County, the State Court of Appeals ruled an 18-year-old sentenced to life without parole must be resentenced. I believe the court erred in this decision. 18-year-olds are adults, and therefore should be held accountable for their actions. They based their decision on a state Supreme Court decision, People versus Taylor, 2022, ruling that life without parole violated the state constitution, which the U.S. Supreme Court basically had already said that it was a violation for 17 and younger. I believe that our state Supreme Court also erred in extending Miller and Jackson to 18-year-olds. When Paul Kraft took that gun from Deaton and shot Bobby, he knew what he was doing was wrong. The fact that he was trying to escape a previous crime by driving away indicates his frame of mind at the time. His actions were not those of a juvenile kid. The bigger question is, why did they take the attendants hostage? To cover their tracks and later dispose of a potential witness? Did Bobby save a life the day that he lost his? Thank you, Your Honor.
Thank you, Mr. Wright. Ms. Bruggeman or Ms. Weiss, do either of you wish to speak on behalf of the people?
Yes, just briefly, Your Honor. I understand that this court is bound by precedent and you have no control over what we're here doing today. And I understand that. That doesn't mean that I agree with the higher courts. You know, Mr. Kraft was 18 at the time that he intentionally shot Bobby Williams. And, you know, the court's surrounded here by law enforcement, and these brave young men and women come to work every day and they protect this community. And, you know, I hear a lot, well, you know, that's what they signed up for. Well, it's 2024. It's probably getting a little frustrating and hard to want to come to work and protect the community when things such as this happen. Okay. And again, I understand this court is bound by the higher court's rulings. When you intentionally shoot someone, especially a law enforcement officer who is doing his job, there's a kidnapping, an armed robbery. Again, I find it hard to believe that that's not life without parole. I support Rick Williams, and I feel bad that he lost that time with his brother. His parents lost all that time with his brother. I would ask this court to sentence accordingly with what this court can do within its power.
Thank you. Ms. Olson, is there anything?
Your Honor, if I just wait,
Oh,
say
you
it,
want to
say
speak
it.
too?
Yeah, I'm sorry. I just want to.
Hold on one second, please. Okay, thank you. All right, go ahead.
Thank you, Your Honor. I just want to just say a few things in response to the memorandums that were filed, and obviously they're lengthy, and Pool and Parks give this court guidance on what they need, what this court needs to address at this resentencing. But I just want to clarify that although the Miller factors are not required for this court to consider, from a proportionality perspective and an appellate review perspective, I would ask this court to do so, and do so on the record.
Ms. Brugman, I did read the briefs, and I am going to go through both the Miller and the Snow factors on the record.
I would only then say a couple more things in line with what Ms. Weiss was saying. The biggest issue here for me in looking at this case is Mr. Kraft's actions. He says he's sorry, and that sorry is not good enough, but he also continues to blame Mr. Deaton for what Mr. Kraft intentionally did. Deaton didn't pull into the gas station, which set this course into action. Deaton didn't pick up the gun. Deaton didn't pull the trigger, not once, not twice, but 3 times. Deaton didn't get back into the car and drive away that day to leave Officer Williams to die. Deaton didn't do any of those things. Mr. Kraft did. Lastly, I would just ask this court, I know Ms. Olson is going to argue that this court is bound to sentence Mr. Kraft to 40 to 60 years. I absolutely do not believe that that is correct. The Pool decision grants this court the ability to sentence Mr. Kraft to, did I say, I'm sorry, I don't know if I misspoke. 40, she's asking 40 to 60, sorry. The Pool decision says that this court is bound to sentence Mr. Kraft under 769.25. Sub 9 of that statute says this requires the trial court to sentence defendant to a term of imprisonment for which the maximum term shall not be less than 60 years. That terminology has been interpreted by multiple cases, which I attached to my sentencing memorandum. It's unambiguous. This court has the ability to sentence to more than 60 years. The Pool court was well aware of 769.25A, which is a completely separate statute. And in line with that, I believe that this court is allowed, and it is definitely proportionate to the offense and the offender in this case, to sentence Mr. Kraft to 40 to 100 years.
Okay. Ms. Olson, I guess I would allow you to address your sentencing brief as well as any remarks before sentencing.
Thank you, Your Honor. And after I make my remarks, Mr. Kraft wanted to.
Well, yeah, he would be allowed to next.
Your Honor, I will keep my remarks as brief as I can. We did file our brief, but we are all very cognizant, as I said before, that we are here today exactly 49 years and 11 months after Officer Williams' death. And Mr. Kraft has been incarcerated for 49 years and 11 months, paying his debt to society. But it's not really a debt that you can ever fully pay. And we recognize that quite fully, Your Honor. Belaboring the facts of the case does not change the fact that Officer Williams died that night. This offense is one that Mr. Kraft has always taken responsibility for. He has never said he did not pull the trigger. In his testimony at one of the hearings in the case, as he cried, and a court reporter in 1975 remarked upon his sobbing as he talked about shooting Officer Williams 3 times with the gun handed to him by his stepfather, Gerald Deaton. He has certainly talked about the events surrounding that. And the events surrounding this offense, Your Honor, are exactly the kind of senseless decision makings that underlie the Miller decisions. I provided the court with a lengthy report from Dr. Daniel Keating, an esteemed neuroscientist from the University of Michigan who studies adolescent brain science, who's testified in many of the Miller cases, Your Honor. And these decisions are senseless. Why did Mr. Huggins and Mr. Kraft get in a car without a change of clothes with Mr. Deaton, who, in the words of Mr. Huggins, had been drinking so much you could smell the alcohol on him like perfume, to go to California? This was the most senseless thing one can imagine. And the bad decisions just kept coming. And they were decisions, bad decisions, one after another, exactly as youth do, exactly as immature adolescent people do. Not all of them, but many. Most adolescent decisions don't result in this kind of outcome. But this is a senseless series of decisions. But again, exactly what's contemplated by the case law. I won't belabor Mr. Kraft's family background that I set forth in the sentencing memorandum, Your Honor. It's there in the original pre-sentence investigation. I've elaborated on it somewhat based on my investigation into the case. But we're not here to discuss and attempt to make anyone feel that Mr. Kraft's background caused him to do that. Instead, what the law contemplates is that kind of background with the poverty and the traumatic death of a parent and all those things that he experienced. Those kinds of things are to be weighed by the court as mitigation of what his culpability should be, not to excuse the offense, but what is the appropriate proportionate penalty for the offense. And so I've set forth those matters in the sentencing brief. So we know that there is that kind of mitigating family background. We know that this senseless offense was just one after another series of senseless decision-making. We know the science, again, in the report that I provided to the court. All of those things are mitigating under the case law, Your Honor. One of the biggest things, though, I think Your Honor must consider, because our Michigan Supreme Court in the case of People versus Skinner said, that we always have to consider the possibility of rehabilitation. Miller says that, Montgomery says that, Skinner says that, all the cases talk about the possibility of rehabilitation. As we are here today, instead of having to speculate, if Your Honor was sentencing an 18-year-old youth, you really wouldn't know what that youth is going to look like in 49 years. But now we have Mr. Kraft, and we have his background, and we have documentation, and we have information about him. Mr. Stevens, the agent Stevenson, said he provided all the documents that I provided to him for the pre-sentence investigation. Those include documents from people who are with Mr. Kraft every day in the Department of Corrections. And they describe somebody who is mature, who is respectful, who is hardworking, who gets along, who goes to extra lengths to help people. It describes someone who participates in charitable activities. There are a couple of older letters about some charitable activities. And when I asked Mr. Kraft, because he continues to do those things, why there aren't more letters, he said, I was not doing that to get letters. And because he has grown, he wants to give something back, whether it's providing food, whether it's providing blankets, whether it's providing whatever he can provide from the position that he's in. He engaged in as much programming as he could, vocational programming. He's worked throughout his time in prison. And so we know, based on a pattern of conduct, that he has rehabilitated. For 49 years and 11 months, he has worked to not be the person who committed this offense, and he is not that person any longer. The prosecution in its memo cites a couple different places in the record where it says he hasn't accepted responsibility or he hasn't discussed some of the family history. This is a record that's very, very lengthy. And I provided the report of Richard Stapleton, who worked many, many years in the Department of Corrections, to give some context to the record. These records are written not for purposes, as Mr. Stapleton explicitly says, not for purposes outside the Department of Corrections. These records are written for the Department of Corrections to use almost in a punitive sense, but also a safety sense, so that they know worst case scenario for every single person They're not for use outside that setting. But the records aren't bad. The records, in fact, are good. Their work reports, as noted in the updated PSIR, all good. This is a person who has worked hard, who has contributed, who helps others. He is a rehabilitated person. I wanted to talk about what would happen, when Mr. Kraft is eventually released, whatever that may be, dependent on the court's sentence. He has a family waiting to welcome him home, stable family. His sisters are both retired professionals. He has housing, he has support, he has plans to be employed, he has plans to give back, and he has everything that he needs to safely reenter the community. The final issue, Your Honor, is the issue of what is a legal sentence for Mr. Kraft. And the proposed maximum sentence of the prosecution is not legal. 769.25 does not stand alone. 769.25 and 769.25A are a sentencing scheme. They have to be read together, and in fact, they reference each other. So 769.25 was the prospective statute going forward from Miller. And that set out a series of things that needed to happen. And that is the statute that says, if a prosecutor files a motion seeking life without parole, if the judge decides not to impose that penalty, then the penalty shall be not less than 60 years. 769.25A is the retroactivity statute. That statute says the maximum sentence shall be 60 years. 769.25 uses that language for cases where no motion seeking life without parole has been filed. The only time it refers back to 769.25 is if the prosecution files that motion, and then we go through those proceedings, and then you're placed into that not less than 60-year category. And the prosecution's quote about what Poole said about 769.25, we vacate defendant's sentence of mandatory life without the possibility of parole for first-degree murder and remand for proceedings consistent with MCL 769.25. And again, 769.25 and 769.25A reference each other and are two interrelated statutes. And this is a retroactivity case where no motion seeking life without parole was filed. So 769.25A applies. The two cases attached to the prosecutor's brief illustrate exactly what I just said. The first of those cases, Bell, is a case that occurred in 2020. So it is a case that clearly falls under 769.25. That is a going forward from Miller case. The second case was actually a Sato case. I don't remember who did the appeal. And that was Mr. Givens. Mr. Givens was a retroactivity case from Berrien County, but the prosecution filed a motion seeking life without parole, and there was a Miller hearing. And once that happens, then the language of 769.25A sends you back to 769.25, which has the not less than 60 years language. So that actually illustrates exactly what I was saying in my briefing. Those two cases, the 2020 case and then the retroactivity case, show exactly what I'm talking about. So the legal sentence here is 40 to 60 years. So that, Your Honor, is the statute, is the sentence I ask you to impose, 40 to 60 years for Mr. Kraft. I ask for his credit for time served as mandated by the statute, which I calculated to be 17,867 days. And that is what we request today, Your Honor. Thank you.
Thank you. Mr. Kraft, is there anything you'd like to say on your own behalf before the court passes sentence?
Yes, Your Honor. First, I would like to comment on what Ms. Brugman said. By offering facts, I'm not trying to make excuses for what I did. I was an 18-year-old kid, and Mr. Deaton, who didn't do all the things you said, had just murdered a man in Ohio not 4 hours before, shooting him 12 times with a .357 Magnum and promising to do the same to me. To the officer and to Mr. Williams' brother. I never meant to hurt anyone. There's nothing I can do to make up for the pain that I caused that family or the damage I've done to the community by taking an officer such as Bobby Williams' life. In my decades in here, I've spent a lot of time with people who don't give a second thought about hurting people. And I never wanted to hurt anybody. And I try to do things to help people as much as I can. I'm sorry. I'm sorry. Just I vow that if the court sees fit to release me, I'll never hurt anyone. That's never a question. That's all I got. Sorry.
Thank you all. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, sentencing guidelines, which don't apply to this case, I apologize, report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication for the law, and the protection of society. We are here today because the Michigan Supreme Court held in People v. Parks that the Michigan Constitution requires that 18-year-olds convicted of first-degree murder receive the same individualized sentencing procedure under MCL 769-25 as juveniles who have committed first-degree murder, instead of being subjected to a mandatory life without parole sentence like older adults. 510 Mich. 225, 244, 2022. With the binding decision of the Michigan Court of Appeals in People v. Poole, 2024 Westlaw 201925, dated January 18th of 2024, finding Parks retroactive, Mr. Kraft must be resentenced and receive the protections under MCL 769.25. All right, in the case of People v. Boykin, 510 Mich. 171, 2022, the Michigan Supreme Court held that courts sentencing juveniles who commit murder must consider several factors, including the mitigating qualities of youth described in Miller v. Alabama, 567 U.S. 460, 2012. The Miller factors are: 1, chronological age and its hallmark features, among them immaturity, impetuosity, and failure to appreciate risks and consequences. 2, the family and home environment that surrounds the juvenile and from which the juvenile usually cannot extricate themselves, no matter how brutal or dysfunctional that environment may be. 3, the circumstances of the homicide offense, including the extent of the juvenile's participation in the conduct and the way familial and peer pressures may have affected the juvenile. 4, whether the juvenile might have been charged and convicted of a lesser offense if not for incompetencies associated with youth, such as inability to deal with police officers, prosecutors, and or incapacity to assist his own attorneys. And 5, the possibility of rehabilitation. Miller 567 US 460, 477 through 478. Ms. Bruggeman and Ms. Olson, and I did state I would also consider the Snow factors as requested because I do think it's appropriate. In Snow, the Michigan Supreme Court directed a sentencing court to consider the following objectives: 1, the reformation of the offender; 2, protection of society; 3, the discipline of the wrongdoer; and 4, the deterrence of others from committing like offenses. I'm going to take a page out of a book of Judge Michael Smith from Hillsdale County, whom I've always had great respect for. And I'm going to read on the record the first 4 pages of the pre-sentence report. I have an updated pre-sentence report filed by Mr. Stevenson and dated April 8th of 2024. I'll start with that and then I will read 2 or 3 pages from the original pre-sentence report. Paul Coy Kraft pled guilty on September 3rd, 1975 to count 4 first-degree open murder, and then Judge Glazier made the findings of first-degree murder. He was sentenced in Lenawee County on December 2nd of 1975 to a term of natural life. The offense stems from the offender shooting and killing Officer Bobby Williams of the Adrian Police Department. The offender and 2 co-defendants were riding in a vehicle and had just robbed a gas station and taken a clerk hostage. Officer Williams had conducted a traffic stop when Paul Kraft exited the vehicle and shot at Officer Williams. The officer was shot twice in the abdomen and once in the neck with a .38 caliber Colt revolver, resulting in his death. The 2 co-defendants were Harold Luke Huggins and Gerald Deaton. Gerald Deaton was convicted of first-degree murder and received a life sentence and died in prison, and he is obviously deceased. Harold Huggins received a prison term of 5 to 50 years for armed robbery, and I think that was stated on the record. He was later paroled, and I don't know if he's still alive at this time. Mr. Kraft's biological father, Wayne Kraft, died of a heart attack in 1965. Mr. Kraft reported that his mother, Thelma Kraft Deaton, is deceased. His stepfather and co-defendant in this case is also deceased. His sister, Barbara Kraft, is deceased. His sister, Shelby Moore, is retired and lives in Colorado Springs, Colorado. His brother, Roger Kraft, is deceased. His brother, Ronald Kraft, is deceased. His sister, Cheryl Hunt, is retired from Honda and resides in Marion, Ohio. His brother, Charles Kraft, lives in Iowa and owns a horse ranch. His sister, Patricia Kraft, is deceased. He reports that he is single with no children. He obtained his GED on June 24th of 1977 while incarcerated with the Michigan Department of Corrections. He has obtained numerous certifications in areas including welding, metal fabrication, small engine repair, horticulture, handcrafts, and gardening. All program and work assignment evaluations were of a positive nature. He was described as a good worker who can get along well with other inmates and staff members. He was described as reliable and respectful towards staff. He has held employment in the maintenance and the plumbing shop, but is retired from working in the prison due to health issues. I didn't even know that you could retire in the Michigan Department of Corrections. That's a long time. He has had 46 misconducts while in prison. The first several misconducts were before they kept itemized records, and we do not have information on those. But the information we received from July 23rd of 1987 through June 21st of 2022, including out of bounds, substance abuse, marijuana, insolence, destruction of property, possession of dangerous contraband, disobeying a direct order, fighting, substance abuse refusal, possession of money, and unauthorized occupation of cell. He has not had any new criminal behavior charges or faced charges outside of prison since his incarceration. He is currently 67 years of age and reports numerous health issues. He reports having liver disease, low functioning liver, and hepatitis C because of tattooing while in prison. He has poor circulation in his legs and bone spurs in his hips. He reports ongoing issues with skin cancer. He denies any mental health issues currently. He reports having no current assets or liabilities. He has no current income. He is receiving financial assistance from family members who fund his account, allowing him to make purchases within the MDOC. He reports that his future upon his release would be to return to the Marion, Ohio area. He resided in this area prior to his incarceration. He would like to reside with his sister Cheryl Hunt and obtain a CDL license. He would like to seek employment as a trucker. He does have positive attributes to take into consideration. He does have a strong work history and completed numerous classes and his GED while incarcerated. His reviews by staff members of the Michigan Department of Corrections are on the positive side. His disciplinary history would not be considered unusual or abnormal considering his length of incarceration. He was 18 years old when he murdered Officer Bobby Williams of the Adrian Police Department. Officer Bobby Williams had his life taken at the young age of 28 due to the actions of Paul Kraft. He received a sentence of natural life on December 2nd of 1975. The last sentence was stricken by agreement of the prosecutor and the defense counsel. We'll now move on to Michigan Department of Corrections Bureau of Probation pre-sentence investigation dated October 27th of 1975 and signed by Thomas J. Bell, the probation officer at that time, for Judge Kenneth Glazier Jr., who I would note his portrait is to my left in the courtroom. Paul Coy Kraft, an 18-year-old single white male, pled guilty on September 3rd of 1975 to an open charge of murder. On September 18th of 1975, the degree of guilt was established as first-degree murder. He has been in the Lenawee County Jail since his arrest on June 30th of 1975. On June 30th of 1975, Gerald Deaton, Paul Kraft, and Harold Luke Huggins left Marion, Ohio for California. Kraft and Huggins had no money, with Deaton possessing approximately $225. They were riding in Deaton's car. At approximately 6 a.m., the trio stopped at the Clark gas station in Tecumseh, Michigan. After filling up with gas, Deaton pulled a gun on the attendant, Terry Hell, and robbed him of approximately $48. Huggins placed the money in his pocket. Kraft had remained in the car. Upon returning to Deaton's vehicle, another customer came to the gas station. Deaton robbed him of $20 at gunpoint. The attendant, Hale, was instructed to get into the car and the four subjects left the scene. While going through Adrian, Michigan, the subjects were stopped by Officer Bobby Williams, Adrian Police Department. Although the identification was not specific, Officer Williams suspected that this was the vehicle involved in the armed robbery in Tecumseh. Well, I added in Tecumseh, but the armed robbery. As he approached the vehicle for the third time, he told the subjects to get out of the car. As Kraft stepped out of the car, he shot Officer Williams twice in the abdomen and once in the neck with a .38 caliber Colt revolver. A short time later, Officer Williams died on the operating table at University Hospital, Ann Arbor, Michigan. The subjects attempted to escape. However, Officer Williams was able to discharge his handgun several times, hitting the vehicle 4 times. This included hitting one of the rear tires. They then abandoned the vehicle a short distance away. Deaton attempted to break into a home, however, was unsuccessful. The 3 subjects then ran afoot, with the attendant Hale being able to escape. A short time later, the 3 subjects were arrested by officers of the Lenawee County Sheriff's Department. Subjects had been consuming intoxicants earlier in the morning. Paul appears to be of average intelligence. He is from a pathetic home situation which has thrived on violence. Paul's father has been in prison for assault with intent to murder. His brother is presently in prison for the murder of a guard at a juvenile institution. His stepfather and co-participant, Gerald Deaton, had been to prison on 2 occasions for armed robbery. His mother had met Deaton by correspondence while he was in prison. In speaking with the mother, this probation officer found her to be rather cold, showing no emotion over her son's involvement in the instant offense. Paul was referred to the Marion County Juvenile Court, Marion, Ohio, on numerous occasions. Many of the contacts involved school truancy, violations of curfew, and traffic violations. He was also referred for receiving stolen property, possession of marijuana, and 2 auto thefts. As an adult, he has had no prior records. Paul stated that for the past 3 years, he has lived on and off with Teresa Gross, at that time age 23, in Marion, Ohio. He was employed part of the time, living part of the time on her support payments from a previous marriage. Paul does not believe that he is guilty of first-degree murder. He stated that he only shot the police officer on the spur of the moment and because Deaton told him to do so. Paul reiterated that Deaton had mentioned killing another subject during an armed robbery the night before and had told them about shooting his best friend during an earlier armed robbery. Paul stated his action was a result of his fear of Deaton. As mentioned earlier, Paul appears to be of average intelligence. He and Luke Huggins considered each other to be brothers. They were going to California without any money. Both have indicated that they thought Deaton had enough money to get them to California. This agent stated, I believe Paul is smart enough to understand that before they got to California, there would be some type of criminal activity. He had knowledge of Deaton's prior history, which included armed robberies, and was cognizant of the fact that he and Huggins could not expect to exist without any money. When the 3 subjects entered Tecumseh, Michigan, Deaton told him to look for a gas station with 1 attendant. I believe Paul knew while they were looking for a gas station with 1 attendant. Paul's explanation is that the police were looking for Deaton as a result of a murder the previous night. By finding a gas station with 1 attendant, there would be less chance of being recognized. Paul is smarter than that. In addition, he told co-participant Huggins to go help Deaton in regard to the armed robbery at the gas station. When stopped by the Adrian police officer, the attendant, Terry Hell, stated that Deaton asked Kraft if he wanted to take care of the officer. Kraft replied in the affirmative and shot Officer William 3 times. The sentence in this case at that time was set by statute, and it would appear to be superfluous for him to make any recommendations at that time. It should be noted that if Kraft and Deaton were both at the same institution, it is quite possible that Deaton will make an attempt at retribution. Respectfully submitted, Thomas J. Bell, probation agent. I'm not going to read anything else from that pre-sentence report. But this time, based on the information, the pre-sentence report and the sentencing memorandums, I'm going to go through the itemized Miller factors. The first factor under Miller is chronological age and its hallmark features. Mr. Kraft was 18 at the time of his offense. He was adult at that time, but under the current changes of Michigan law, he would be deemed a juvenile. This places him squarely in the midst of adolescent brain development, the science underpinning the law in youth sentencing cases. Due to the trauma and neglect he experienced in his young life at that point, he was not operating even as an average youth of that age. 2, and the trauma and neglect are itemized in the sentencing memorandums. Family and home and further in family and home environment. Mr. Kraft was born in April of 1957, the 5th of what would eventually be 8 children of Wayne and Thelma Kraft. Wayne had a 4th grade education, Thelma approximately an 8th grade education. Wayne was sentenced to prison in 1957 and was on and off involved in their lives, but not present. Wayne died at the age of 35 when Paul was around 8. The family fell deep into poverty when the father died. Mother was 28 years old, had 8 children, and she worked multiple jobs and was unable to be present at home with the children. She was described as a little mouse who tried to take care of the kids. The mother taught the children that if you pressed a pillow against their stomachs, they would not feel pain when they were hungry. It's no surprise that at age 12, Paul began to use drugs, beginning with marijuana, LSD, speeders, downers, and 17 snorted heroin. He dropped out of school, completing only the 8th grade, was in and out of youth detention facilities, and his mother was not able to provide structured guidance and nurture needed by any of her children. He received a skull fracture in a car accident when he was 16. Overall, the description in the original pre-sentence report is correct. Mr. Kraft came from a pathetic home situation which thrived on violence. There is no question that Paul at that time was adversely impacted by the circumstances of his childhood and home life. According to the Center for Disease Control and Prevention, adverse child experiences, known as ACEs, are potentially traumatic events that occur in childhood between the ages of 0 to 17. They are aspects of a child's environment that can undermine their sense of safety, stability, and bonding. Some examples of ACEs include experiencing or witnessing violence, physical, verbal, and/or sexual abuse or neglect in the home, witnessing violence in the community, or having a family member attempt or die by suicide. Additional examples including growing up in a household where family members have substance abuse or mental health problems and/or instability due to parental separation or household members being incarcerated. Paul did not have the benefit of a home life and support that allowed him to obtain the type of experiences and treatment he needed as a young child and later as a teenager. Looking at the juvenile record, he was repeatedly returned to the environment that spawned his problematic behaviors. This is in keeping with Miller's discussion of how children cannot remove themselves from such an environment, and the court is required to consider those factors under 1 and 2. Factor number 3, circumstances of the homicide offense, including familial and peer pressures. The horrendous and terrible shooting of Officer Bobby Williams occurred in a scenario that is an example of a classic Miller situation. Paul was in the company of his stepfather, Gerald Deaton, and his friend, Harold Lake Huggins. They left Marin, Ohio to travel to California. It is important to note that Paul had every reason to fear Deaton due to Deaton's prior record of murder. As this court recognized, well, as Judge Glazer recognized back then, Deaton was clearly a bad and dangerous man, and he was also an authority figure to Paul, as well as being the leader in the situation. It was also recognized that arguably Deaton made the decisions to commit all the crimes and how to do them. This is cited from the opinion and order issued by the Honorable Kenneth B. Glazer Jr., denying relief from judgment on May 22nd of 1991, page 5. Factor 4, the incompetencies of youth and Paul's interaction with the legal system. Paul admitted to killing Officer Williams. He pled guilty to 1 count of open murder as a result of a plea bargain. Paul's understanding, based on the advice of his counsel, Klein Durst, which I don't know, but some people in this room may remember. Paul's understanding, based on the advice of his counsel, was that he could be found guilty of manslaughter, 2nd-degree murder, 1st-degree murder by the judge. As noted by the court, Mr. Glazer stated, Judge Glazer stated that Mr. Kraft did not receive much by this plea bargain, although the court did not believe that Mr. Kraft had given up much. Opinion in order by Honorable Kenneth B. Glazer Jr. on the same denial of relief from judgment, May 22nd of 1991. He did in fact give up his constitutional right to a jury trial wherein a jury may have considered duress in the circumstances in a different light, resulting in a lessened conviction by any alternative outcome. But any alternative outcome is unknown because this youth did plead to open murder. The court record is lengthy, and it is clear from Paul's numerous filings that he as a youth had anticipated being punished for the shooting of Officer Williams, as he should have been, but that he did not understand or anticipate that he would in fact be sentenced to die in prison as a result of his plea. Factor number 5, rehabilitation and reentry into society. When Paul entered prison in 1975, he was an 18-year-old youth who weighed 130 pounds. He was placed in the Michigan Reformatory, which at that time was a notoriously violent prison. Former warden Pamela Withrow writes about the environment at MR prior to the days when she became warden and introduced substantial and enduring changes. Blood on the floor every day was how the former warden, Dan Bolden, described the climate at the reformatory. They housed high security young offenders, and the culture of violence was a point of pride for the staff. They were referred to as the gladiator school. When Paul entered prison, prisoners were serving life sentences were assigned to high-level correctional facilities regardless of their age, and were at risk of violence and victimization as well as predation, as described. Strike that. Paul struggled in his early years of incarceration, but did demonstrate continuous improvement over the years. As stated previously, by Mr. Stevenson in the MDOC report, his number of misconducts is way below average and are classified, most of them as class 2, such as out of place. He continues to be at level 2 security, the lowest level a lifer can be, and he has been for many years. Mr. Kraft has demonstrated a continuous pattern of seeking out education, employment, and charitable opportunity for decades. Mr. Stevenson received certifications, letters of application, appreciation for his contributions and his community service work, and those were provided with the pre-sentence report to both attorneys. In 2012, Paul Kraft's compass scores noted him to be at low risk of violence or recidivism, the lowest rating he could receive. The narrative portion noted that his low cognitive, behavioral, psychological score indicates the likely absence of blaming others, making excuses, or minimizing the seriousness of their offense. They're unlikely to lead a high-risk lifestyle or make impulsive decisions. A cognitive therapy program does not appear to be needed, as described in the report. Compass is used as by the MDOC as an accurate prediction tool of the likelihood of success and needs. His compass scores are noteworthy and support that he has in fact been rehabilitated. Significantly, juvenile lifers as a whole are a population who rehabilitate and do not recidivate. Prosecution in this case has requested a sentence of 40 to 100 years. And I understand why they're asking for that sentence, as well as the people in this room. This is not allowable under the sentence and the law in the state of Michigan. If you have an issue with that, that's something you take up with your state representatives, your senators, and you lobby for that. But under the current law, this is not allowable. This is not allowable under the statute. The Michigan Supreme Court has recognized the statutory maximum for cases on collateral review as being 60 years. The prosecutor has agreed that the minimum sentence is 40 years. So it is the sentence of the court that you will serve a period of 40 to 60 years with the Michigan Department of Corrections. Oh, I wanted to add, under People v. Boykin, Michigan, or 510 Mich 171, 190 through 191, 987 Northwest 2nd, 58, rehearing denied. MCL 769.25 is the relevant statute outlining the sentencing procedure for juvenile defendants convicted of these enumerated offenses, including first-degree murder. In enacting the statute, the legislature differentiated between two plausible outcomes for offenders who were convicted of certain enumerated acts committed before they turned 18. A defendant could either receive a term of years with a minimum sentence of 25 to 40 and a maximum of 60 years, or if the prosecution filed a motion for the court to consider life without the possibility of parole. But Boykin expanded to 18 years by People v. Parks. So that does not apply here, and the maximum sentence the court can give is 60 years under the new statute and case law. So, Mr. Kraft, it is the sentence of the court that you will serve 40 to 60 years with the Michigan Department of Corrections with credit for 17,867 days already served. There are no court costs. There's no crime victim rights here. Anything is applicable because of the date of the sentence.
I don't believe so.
Yeah, they didn't assess that. Anything else to add, Ms. Bergman?
No.
Ms. Olson?
No, Your Honor.
So, Mr. Kraft, we are going to provide to you through the Michigan Department of Corrections your notice of right to appellate review. They'll have you initial and date one copy. That'll get sent back to us, hopefully, just to acknowledge you received the paperwork. The other 2 copies are for you. If you wish to appeal this sentence, you can fill out the information on the form and mail it to the address listed on the form within 42 days. That concludes the sentencing. Thank you.
Thank you.